Hi everyone, I'm Vitro here, legal and management consultant from Bangalore. Here I do to talk on certain concerns between the Occupation Safety Health Code 2020 and the State Shops and Commercial Establishments Act. This I would like to raise certain concerns. So it is for everybody to think about it, debate, and how best can we resolve this is an issue according to me. I will make a brief presentation on this. Kindly have a look at it. Let's see. Wait for the. I will share the screen. Okay, just hold on. Yeah. So these certain concerns on the Occupational Health and Safety Code and the state level Shops and Commercial Establishment Act. What are the areas of concern according to me? It is just my own thought, my own this one. Let's debate it. Of course, the contents of the presentation are purely my own views. These were meant for debates, opinions, or even scrutiny by the legal practitioners, etc., and including the state and central government people. This article is not intended to substitute any legal advice. It is only purely my own views. This is the disclaimer I'm going to share, talk with you. Now, here, all of us are very familiar with the provisions of the code, Occupational Health and Safety Code, and even the central government has drafted rules, and even most of the state government also have drafted the rules very elaborately. Let us look at this. So for instance, the Occupational Health and Safety Code deals with the working conditions of the employees and the workers. The shops and establishment also deals with the terms and conditions of employees. See, both are looking after the terms and conditions of employment under both the legislations. If you see, the code has repealed many of the legislations centrally enacted with state rules for implementation. They have repealed certain centrally elected rated legislation like for Factories Act, Mines Act, Plantation Act, Contract Labor Act, etc., all these things. But the code has not repeated any state legislations. Probably you may observe the Shop and Establishment Act is not repeated. Welfare Fund Act, state level, National Festival Holidays, it is not at all repealed. Arising out of this, the enforceability of the Shops and Establishment Act with rules and the controversies were deeply examined in the court. There are certain issues likely to crop which I want to share with you. Are there any overlappings? Or what is the extent of redundancy? This, I think, we need to examine it as there can be resolution. I made an attempt to analyze and present to all legal practitioners, HR veterinary, and no exception to state and central authorities as well. Now let's look into one by one. As far as the Shop Act is concerned, as you know, there is no minimum number prescribed at all. Even if there are two employees, the establishment has to be registered. Even one, it has to be established. But whereas if you see the Occupational Code, the coverage limit is 10 or more employees. Here the definition of establishment under the code is 10 or more persons employed. 10 or more. Here in the Shop and Establishment Act, there is no limit. Now the question is, here then controversy. Another thing is that it covers all the employees except persons holding the positions of management under the Shop Act. All of us know about it. Now here, the workers are defining the establishment. They have mentioned establishment wherein 10 or more workers are employed. That's exactly what has been defined under the code. Now, does it mean that non-workmen are not covered under the code as far as service conditions are? And look at here, the shopping establishment covers everybody. Now, again, there is appears to be a imbalanced controversy. And let us take the registration of establishments. Here, registration has been completely mandated under the Shopping Establishment Act. Under this code, registrations also, they may have mentioned it, but the thing is, in all the draft rules we see, there is no registration establishment for commercial establishment. It is silent in all the both in the code as well as in the draft rules. It talks about factory registration, mines registration, plantation registration, Interstate Migration Act, construction bill. All these things have been mentioned of registration, but whereas registration shopping establishment is not at all, commercial establishment is not mentioned. So here again, there is a picture some controversy. As all of us know, some of the states' acts prescribes letter of appointment. Now, under the code also it specifies all employees must be issued with a letter of appointment. For instance, in the draft code, they mentioned Form X and Form X1. They are mentioned. Now, here also there is some kind of duplication. And here, this is very important. Under the Shop Act, it talks extra wages of overtime. Here, the word employee has been mentioned. Look at here. Employee has been mentioned. And if you see the definition of applicability of the Shop Act, employee means all persons employed in the establishment except person holding position of management. That is senior level management, they are not employees for the purpose of overtime. But look at here under the code, extra is when the word again, the worker has been mentioned. Worker has been mentioned. It means that the supervisory and managerial personnel are excluded from the payment of overtime, whereas the Shop Act the other way. Now, this is a few concerns. And in the Shop Act, you know that almost all the state acts says that eligibility for annual leave is 240 days, and then only he will get the eligibility for annual leave. That too at the rate of 1 day for every 20 days work. And mostly Shop Acts and Shop Acts specify casual leave and also sick leave also. And most of the Shop Act, the accumulations vary from 30 to 60 days in many of the act. But look at the under the code, it is reduced to 180 days. If a person has 180 days, he will get the annual leave at the rate of 1 day for every 20 days. But no stipulations on casual leave or sick leave here. Look at here. Here, the code doesn't talk of casual sick leave, whereas the Establishment Act, Shopping System says casual leave and sick leave with this kind of a condition. This one. Now, as you know, under State and Shop Establishment Act, submission of annual returns. Way to do it. But here, under the code, there is submission of combined annual returns. Line is mandated. And this is a combined annual return for covering all the codes. Very kind of, that's very good, no problem. But sitting here also we need to file annual return under the Shop Act. Again, this is a controversy. Then look at here, wage registers, attendance registers, register of payment of wages act, minimum wage act, are mandated under the shop and establishment to maintain register for deductions, advances, blah blah blah, everything. We have to maintain it. But now here under the code, it is also prescribed registers. Well, here again there is a duplication. We have to maintain registers under this, or should we maintain this also? Again, this again a multiple issue. When applicable to the Contract Labor Act is irrespective number of employees. Suppose you under the contract existing Shop and Establishment Act, if you got 3 employees of your own, but you engage in more than 20 contract labor, the act applies here. But here under the code, it's a different thing. This chapter applies contract labor only if you apply the establishment is defined as 10 or more workers. Then again contract labor will applies or not is a big question here. Then look at the penalties. Penalties and offences are applicable both to any shop establishment act employ more than 10 workers. Here the quantum of punishment on the shop and establishment is less, whereas the quantum of punishment in the code is exert much more, much more. Again, this is an issue has to be looked into and addressed. Now here, of course, we see here, these are some few concerns I have raised it. Now, of course, some of the provisions may be helpful to employees, some may be helpful to employer. There is a different issue, but at the same time, the concerns and controversies are bound to be there. This will lead to what you call controversies and varied opinions bound to take place. Now, the kind of thing, and it is a matter of interest and debatable. May be argued that the shop architect may be repugnant and void. We may have to do that. We don't know. But this one thing. Now let us see what it talks about. Let us see what is our Constitution of India talks about this. Talks about this. Let us. I invite your attention to Article 254 of the Constitution. See here, inconsistency between laws made by the Parliament and laws made by the legislature. Article 254 clearly specifies. Here, what it says is that if the Parliament has enacted law, and the state legislature have made a law, and to that extent, the state legislature shall be void. Shall be void. Under these circumstances, the law enacted by the Parliament will never get invalidated. But whereas the act made by the state becomes repugnant to the extent of repugnancy, it is void. So it is a very peculiar thing. To the extent of repugnancy, it is void. If you take the whole act, it is a big issue. It is a big issue. This highly is a very debatable issue. So enactment made by Parliament legislation says, subject to the provisions of this Constitution, the Parliament may make laws for the whole or part of the territory of India. Legislation may take laws for the whole or part of the state also. No law made by the Parliament shall be deemed to be invalid on the ground it would have extraterritorial operation. So what happens? The code becomes valid document, and to the extent of repugnancy, these laws made by the state governments, in case of repugnancy, that becomes void. That becomes void. So this is a careful analysis what I'm going to present to you. And here also, same thing I just call the commentary. Articles, so what it says, subject to the provisions of Constitution are eligible to make laws for the entire or any part of the territory of India. Clause 2 says that if a law has been made by the Parliament, it shall not be deemed to be invalid on the basis of that maybe extrajudicial takes effect outside territory of India. This kind of thing. Now again here, a law made by the Parliament shall not be invalid, shall not be invalid for the reason that has got extraterritorial operations, according to Article 245.2. So this is the question which rises for a highly debatable issue. There are, of course, there are a number of decisions of the Supreme Court on this Article 245. There are a number of decisions. For want of time, I'm not able to quote all those things. But here, a number of cases where it has held that the law made by the Parliament stands and other things becomes invalid. There are any number of decisions on this matter. Now here, now the questions are there any dependencies? Are there any inconsistencies? In view of the points out, we can opine that ultimately the Shop Act renders itself void. Now, this is a question. This is a question. This is a question to be debated by everyone, by legal experts, by state and central government authorities, or even HR fraternity, anybody. Of course, maybe I'm wrong or right. That's the difference, but I'm raising a concern. I'm raising a concern. It's for everyone to address it. Now here, coming to the point, the intention of the courts, as you know very well, it is used to do business. The intention is to avoid multiple registrations, multiple runs, multiple register compliance systems, all everything has been said. Now, but look at here. There are multiple registrations here, there, multiple registers here, also there, multiple annual returns here, also it is there, and changes in service condition like leave with different quantum here and different quantum, payment of overtime again different criteria here, different criteria. So, friends, I am raising this concern, and this is why I'm making the presentation. This is for every one of us to see that how best to be addressed. That's why I made a brief presentation. So this is for everyone. Please debate it. Let's. I think it's high time that every one of us should look into it, debate ourselves, and take some preventive steps. Either way, by the state or central government, it is better to take preventive steps rather than after the code comes into picture, these issues will come and then a lot of litigations and a lot of things will take place. So here it is now, time is there because still the codes are not being effective. Time is there. I think let us think about it and we should take certain steps. Okay. Thank you for watching this. Thank you for listening. So here I request every one of you to discuss amongst debate and let us see and how best we can draw a conclusion. Whether I'm maybe wrong, I don't know. But here we have to see. So thank you very much. Wish you all the best.